I shall now describe the remedy briefly. As I've said, it's set out in detail in the memorial. The 2005 law foresees 3 means of redress in respect of the applicant's complaint that they are denied access to their property in northern Cyprus: restitution, exchange of properties, and compensation. The law also provides redress by way of compensation in respect of the applicant's complaint that they have been denied the use of their property in northern Cyprus. This may be claimed in addition to restitution, exchange or compensation in return for the immovable property. In fact, while pecuniary damage for loss of use can be claimed before this court only from 22 January 1990, the date when Turkey recognized the competence of the court, no such limit applies to claims for loss of use before the IPC. In addition, the law provides for non-pecuniary damages for violations of the right with respect for the home under Article 8 of the Convention. Property ownership is not a requirement per se for an Article 8 remedy under the 2005 law. The law provides for non-pecuniary damages for applicants who can show that they owned the properties in 1974, as well as heirs to such properties. The precise scope of these provisions has yet to be determined. The issue has not yet arisen for decision by the IPC. More generally, it will be for the IPC to interpret the 2005 law and to do so in conformity with the European Convention in deciding upon claims for non-pecuniary damages. Moreover, Article 8 violations may also be brought to the district courts in the TRNC, which apply the European Convention as directly applicable law. The remedies provided are administered by the independent and impartial IPC. This was set up in accordance with guidance provided by the court. And there is, of course, an appeal to the High Administrative Court. Notwithstanding efforts by the intervener to discourage Greek Cypriots from applying, the IPC has received wide acceptance. As I've said, since its establishment in 2006, it has received 433 applications. As of today, 85 applications have been concluded, and of course a single application may include a number of applicants. In 4 cases, the IPC reached a reasoned decision after a formal hearing. In 4 friendly settlement cases, the applicants obtained restitution and compensation. In 74 others, the applicants received compensation. Exchange of properties plus compensation was approved in 2 cases. In 1 case, the applicant agreed to restitution upon the settlement of the Cyprus problem. To date, the IPC has restituted over 360,000 square metres of land and paid over £37 million in compensation. These figures, we say, testify to the effectiveness of the remedy. Mr. President, members of the Court, the applicants have raised numerous issues, large and small, in an effort to show that the remedy is neither available nor effective. In the time I have, I cannot deal with all of them. In any event, in our view, they lack seriousness or credence. I'll begin with a preliminary point concerning the applicant's so-called evidence. Since none of the applicants before you has sought to exhaust domestic remedies before the Commission or the High Administrative Court, there is no evidence whatsoever to show how the procedure would work in their case. The remedy has clearly worked satisfactorily for others. So what do the applicants do? They seek to rely on statements from others who have applied to the Commission and were, it is claimed, dissatisfied, even though none of them appealed to the High Administrative Court, which is an important stage in the domestic remedy. The applicants seek to rely upon various kinds of evidence. This includes 57 statements and a report by the intervener's own Department of Lands and Survey. Turkey does not accept the accuracy of this so-called evidence, which would need to be properly tested in the usual way if the court were to have regard to it. It should be noted that the statements were prepared specially for the present hearing. To adopt the language of the International Court of Justice in its 2005 judgment in DRC and Uganda, the court should, and I quote, treat with caution evidentiary materials specially prepared for the case. We have been told nothing about the circumstances in which the individuals concerned came forward or were selected, or how the statements came to be made to the Greek Cypriot police. But it is clear that they were obtained under a certain pressure from Greek Cypriot authorities who were interrogating persons who had applied to the IPC. Those making the statements probably thought that by doing so, they would make amends for having applied to the IPC. It is, moreover, clear from the terms of the statements that they were responding to predetermined and leading questions. All gave answers on the same pattern. In any event, these witnesses are not before the court. They have not been examined under oath or solemn declaration. A common feature of all the statements is that they are generalized and vague. They lack detail. They lack context. Turkey is hardly in a position to investigate such allegations. We are, however, satisfied that the statements give a wholly distorted and false picture of what actually happened in the IPC. Indeed, in 3 cases, those who made the statement subsequently entered into friendly settlements endorsed by the IPC. And for all these reasons, we would invite the court to disregard the bundle of 57 statements. The intervener has submitted what it calls a valuation report. This report, too, has been prepared specially for this case. It is self-serving. It cannot in any sense be regarded as an expert report or neutral. It, too, should be disregarded. The true value of the properties is best seen by looking at the friendly settlements voluntarily reached. For example, very recently, Angulas Estates Limited, which had initially sought £14 million sterling, agreed to a settlement under which they received £9.3 million. Angulas, by the way, had an application pending to this court. We understand that it will now be withdrawn. The applicants make the purely political point that, in their words, the remedy requires submission to an occupying power, that for some, submissions to the IPC is a form of betrayal. Such attitudes have been encouraged by the intervener, which for its own reasons does not want the IPC to succeed. Of course, the applicants may choose not to exhaust the remedy, but they cannot then come before the court and say they are not required to exhaust it because they do not want to.